Good afternoon, ladies and gentlemen. I'm Andrew Samwick, the director of the Nelson A. Rockefeller Center here at Dartmouth College, and it's my pleasure to welcome you to this year's Brooks Family Lecture. Established in 1990 by a gift from Dexter Brooks, a member of the Dartmouth class of 1947 and the Amos Tuck School class of 1949, the Brooks Family Lecture has been a mainstay of Rockefeller Center programming for over 2 decades. Mr. Brooks passed away this past summer at the age of 84, and we're very honored to be able to carry on a part of his legacy at Dartmouth through this annual event. We are fortunate today to have with us Mr. E. Duncan Getchell, Jr., who is the Solicitor General of the Commonwealth of Virginia, to speak to us about healthcare litigation, the United States versus the United States government. Virginia is one of 28 states with current litigation related to the passage of the Patient Protection and Affordable Care Act. The Supreme Court will be hearing arguments on those cases this spring, and its ruling on the matter will set the stage for health policy for years to come. Put simply, the health care legislation passed in 2010 includes a provision that constitutes an individual mandate, a requirement that an individual citizen engage in an economic transaction. At issue is whether the federal government in fact has the power to impose such a requirement. Regardless of your views as to whether universal health insurance coverage is the appropriate public policy, you need to be very concerned about the constitutionality of the laws that achieve that outcome. As Solicitor General, Mr. Getchell is the counsel of record in the Commonwealth's legal action against the federal government. Prior to joining the Office of the Attorney General in 2009, Mr. Getchell headed the Appellate Litigation Practice Group at the law firm of McGuire Woods. He's a fellow of the American Academy of Appellate Lawyers, an elected member of the American Law Institute, and a permanent member of the Fourth Circuit Judicial Conference. He graduated with a BA and high honors from Emory University and with a JD from Duke University, where he served on the staff and the editorial board of the Duke University Law Review. After law school, Mr. Getchell spent 2 years as a captain in the U.S. Air Force, attached to the Office of the General Counsel, as a participant in the Air Force Honors Program. In 2007, he was nominated by President George W. Bush to a seat on the United States Court of Appeals for the Fourth Circuit. Ladies and gentlemen, please join me in welcoming Duncan Getchell.
I have been asked to discuss where we are in the healthcare litigation. And the short answer is March 26th, 27th, and 28th. The Supreme Court will be hearing oral argument on various issues presented in the case. It is currently allotted 5.5 hours for the argument over those 3 days. There has been a request made for even more time on the Medicaid issue. If you're interested and have the time, you can go to the Supreme Court website, and the afternoon of each argument day, the audio will be up, and you can listen to it if you so desire. They also, for those who wish to be more economical with their time, will put up that afternoon also a rough transcript, and you can read the exchanges. Now, the players involved are the Department of Health and Human Services, which is represented by the Solicitor General of the United States. There are 26 states who brought suit in the district court in Florida, which ultimately went to the 11th Circuit, where the mandate and penalty were declared unconstitutional as being beyond the outer limits of the Commerce Clause. The 26 states there are represented by Paul Clement, former Solicitor General of the United States. Another party is the National Federation of Independent Businesses, which is separately represented by Michael Carvin. The first issue to be taken up by the court will be a jurisdictional question. Do individuals have the ability to bring a suit against the mandate and penalty, given the fact that the penalty is collected by the IRS as a matter of tax reporting, and that part of the law is codified in the Internal Revenue Code. Our case, the Virginia case, which was filed in the Eastern District of Virginia after the General Assembly had passed something called the Virginia Healthcare Freedom Act, ultimately survived a motion to dismiss in front of Judge Hudson. It survived the cross motion for summary judgment brought by the United States and our motion for summary judgment declaring the mandate and penalty unconstitutional was granted. When we got to the Fourth Circuit, we had a panel of the court that held that the Commonwealth of Virginia lacked state sovereign standing and that the individuals lacked standing because of the Anti-Injunction Act, which limits suits brought with respect to tax challenges. Anyone who's interested in the state sovereign standing issue, there is an article that is at the printer that was written by Attorney General Cuccinelli and myself and the civil deputy in Virginia, which is about to appear in the latest issue of the Stanford Law Review. So if you care about that issue, you can see that coming up soon. Virginia, did file a petition for cert from the ruling of the Fourth Circuit. That petition was neither denied nor granted. So in the parlance of Supreme Court practice, it is being held, presumably pending the outcome in the 11th Circuit case, which itself probably will come down the first week of June. Now, the status of the AIA standing challenge has only really fared well in the Fourth Circuit. The United States refuses to argue that the individuals are barred by the AIA. And so the court has appointed Robert A. Long as amicus curiae to argue that the AIA does bar the suit. Now, the AIA basically is a pay and challenge statute. It says that with respect to the assessment and collection of taxes, that you have to pay under protest and then challenge the assessment in the tax court. It obviously has an architecture that doesn't make any sense whatsoever with respect to the mandate and penalty, because if you were going to pay anything first, you'd be paying for the insurance. And then you obviously couldn't sue the federal government to get the money back. So I think it is widely assumed that the Supreme Court will not accept that the AIA is a bar, but it is the first argument up because it is logically the threshold question. Does the court have jurisdiction? The second day of argument is on the merits with respect to whether or not the enactment of the mandate and penalty exceed the outer limits of the powers, enumerated powers conferred on Congress. That is set down for an hour for the Solicitor General and an hour for Clement and Carvin. An ordinary argument at the Supreme Court is an hour for both sides, 30 minutes aside. Allowing this much time to develop these issues is not something the court has done in modern times. It used to be in the early days of the Supreme Court and through the 19th century, that the right of argument in the Supreme Court was unlimited. And if you look at the U.S. reports from the early days, the seminal cases from the Marshall Court, for example, they had the practice of printing a summary, the reporter's summary of the arguments of counsel. And you will see that the arguments went on for days, which led Chief Justice Marshall to write that the acme of the judicial talent is the ability to stare a lawyer in the eyes for hours at a time and not hear a word he says. But I suspect that will not be the situation for these arguments. The third day is devoted to remedy. Assuming that the mandate and penalty are unconstitutional, what is the remedy? In the Virginia action, Judge Hudson struck the mandate and penalty and nothing else, despite the fact that the Department of Justice had conceded that if the mandate and penalty fell, all of the private insurance regulations would also have to fall, because the mandate and penalty are the policy linchpin for making those changes work. In the Florida action, the judge did strike down the entire law, but when the 11th Circuit upheld him on the merits with respect to a remedy, it too only struck the mandate and penalty. What you should do when you strike down part of an act is legally under the pigeonhole of something called severance. The court asks the question of what can be severed as unconstitutional and what can be allowed to remain. And the most recent case on that is from the 80s. It's the Alaska airline case. And it set up two tests. One is called the legislative bargain test. If it can be determined that the law would not have passed at all but for the stricken piece, then the whole law should go, because Congress never intended the rest of it to function by itself. That notion has been in the case law for over 100 years, but at no time in the 20th century that I'm aware of has it actually ever been employed. There is a lesser test which is ask the question, what could independently function in the way Congress intended it to function if the unconstitutional part has to be thrown out? And there, I think the answer comes back to at least what the Department of Justice conceded, which is that the private insurance regulation would not stand. Virginia, in its case, argued that because Congress said that it was redesigning the way that all health care was paid for, we made the argument that even under that second test, that all the financing provisions, including the changes in Medicaid, should be stricken. With respect to that argument, the court is allowing 90 minutes and then 30 minutes for an amicus. The final day is devoted to a Medicare challenge brought by the 26 states. And this goes under the legal pigeonhole of commandeering. There is a clear line of authority in the United States Supreme Court that the federal government, Congress, cannot commandeer a state to administer federal law. So when the Brady gun bill came up in the Supreme Court, the requirement that local sheriffs conduct the background check was found to be commandeering and was stricken. But here, it's not strictly true that any state is being formally commandeered, because it's been held ever since 1923 in the case of Massachusetts versus Mellon, that if a state under a federal spending powers act has the choice of accepting money or not, then if they take the money, they have to accept the regulation. And what the states are arguing in Florida is sort of a quasi-commandeering theory, something I've heard as likened to the crack cocaine theory of commandeering. You've habituated us to this program, and now it's a bait and switch, and we have to spend so much more money than we want to, that we ought to be able to challenge the act as being beyond the powers of Congress. There actually was a decision when Elizabeth Dole was in the cabinet where the Department highway funds were being conditioned on all states going to a 21-year-old drinking age. And that went to the Supreme Court. The Supreme Court said it was not commandeering, but it reserved the possibility that a program could be so fundamental and so woven into the state's administration that it would be coercive simply to say, well, you took the money, but that's just, for now, it's dicta, and now the Supreme Court's going to take up whether or not it has any vitality, and that, as I say, will be the third day. I am willing to take questions on any of those subjects when we do the question time, but my own presentation is going to be limited henceforth to the merits issue under the Commerce Clause, whether or not the power to command one citizen to purchase a good or service from another citizen is within the scope of the Commerce Clause. And in order to understand how that issue gets framed, we should look at the fact that every enumerated power in Article 1, Section 8 of the Constitution is listed seriatim, and at the end is the necessary and proper clause, which gives Congress the power not merely to act within the enumerated powers, but to use methods that are necessary and proper in order to make the exercise of authority under the enumerated powers work. And if this mandate and penalty are constitutional, it'll be because of the operation of the necessary and proper clause combined with the Commerce Clause. Now, there is generally a presumption of constitutionality that attaches to federal enactments, congressional enactments. Indeed, before the U.S. Supreme Court ever first exercised the power to strike down a federal law in Marbury versus Madison, Justice Chase remarked in Hilton versus United States in 1796, as I do not think the tax on carriages is a direct tax, it is unnecessary at this time for me to determine whether this court constitutionally possesses the power to declare an act of Congress void on the ground of its being made contrary to and in violation of the Constitution. But if the court has such power, I am free to declare that I will never exercise it, but in a very clear case. And commentators generally view this as the foundation for a presumption of constitutionality. However, process may matter. Justice Breyer, in his book Ordered Liberty, has suggested that courts should be solicitous of exercises of federal power by Congress, because Congress is reflecting the will of the people, and striking something down is interfering with the will of the people, and courts should be modest in doing that. And he suggested that that kind of deference should apply where Congress had taken a hard look at its own authority. Well, what we have here is what Democratic pollsters Pat Cadell and Doug Schoen have said is the most reviled piece of legislation since the Kansas-Nebraska Act. The Kansas-Nebraska Act was famously adopted by employing parliamentary shenanigans. And so it was widely viewed as having the common fame of being illegitimate. Well, we all remember the process that was used for the adoption of the PPACA. It was something where a dummy bill was debated on the Senate. A substitute was produced at the last minute. The act passed the Senate on a strict party line vote with no votes to spare on cloture. Then intervening special election in Massachusetts left the majority party without sufficient votes to reimpose cloture, and therefore the act could not be changed in the House of Representatives. So it was, even though it was widely thought that that everyone had intended to change it further because it was not perhaps workable as written, they couldn't, and therefore it passed unchanged through the House of Representatives with 5 votes to spare. The Kansas-Nebraska Act resulted in a decimation of the Northern Democrats after it passed. PPACA caused the Republicans in the House to gain more seats than they had gained in 70 years. So perhaps Cadell and Schoen's analogy is not off the mark. But I would suggest that the act, because of these process issues, doesn't come with a very robust presumption of constitutionality. Furthermore, the Supreme Court has taken to noting that there is a presumption of unconstitutionality if Congress is claiming a novel power that it has never sought to exercise in 200 some years. And in Bond versus United States, which had to do with the constitutionality of shielding the appointment powers with respect to the Financial Oversight Accounting Board from political and executive control, the Supreme Court said, perhaps the most telling indication of the severe constitutional problem is the lack of historical precedent. And in a case called Prinz versus United States, the court said the fact that Congress has not asserted a particular power for 200 years, quote, tends to negate the existence of that power. I argued a case in the Supreme Court on December the 1st of last year called VOPA, Virginia Office of Protection and Advocacy, versus Stewart, in which the court again noted, although they ruled against me, alas, with a strong dissent from Chief Justice Roberts and Justice Alito, they did repeat that as a rule of thumb, novelty of a claimed power is a warning sign that Congress may not have it. So the fact that Congress heretofore has never claimed the power to require a citizen to purchase a good or service from another citizen tends to negate the existence of that power. And we should note that just before the bill was taken up seriously, the Senate Finance Committee asked the Legislative Research Service whether or not a mandate and penalty would be constitutional. And they received a fairly dusty reply. The answer was that the fact that this has never been done before is problematic and the outcome is uncertain. When the so-called Hillary Care debate was taken up, the same question was asked to the Congressional Budget Office, and they replied, quote, "A mandate requiring all individuals to purchase health insurance would be an unprecedented form of federal action." So, does this matter? Is this just a debate about what the long-dead founders thought was appropriate? I think it matters a lot because as the Attorney General and I argued in an article that was published in the Texas Journal of Law and Policy in the fall, in an article entitled "Why the Healthcare Litigation is About Much More Than Healthcare," having a power in Congress that has no principled limits fundamentally alters the relationship between the national government and the citizen in a way that you may like the policy of health care, but query whether you'll like the way the power is used in some other context. So we think this is probably the most consequential case about government policy in a generation, and I think you should watch it with much interest. When we brought the suit against the federal government, we also made another point, which is the arguments against the constitutionality of the mandate and penalty are doctrinally modest. We pled in our complaint that a modern welfare state, regulatory state, of course can have a national health care policy if it has the political will and the political capital to enact it through the traditional taxing and spending powers. But they didn't have the political capital and they didn't have the political will to do that. And so they came up with this Rube Goldberg device for making everybody get into the market for insurance that, again, is not supported by existing precedent. What we say is that our challenge is supported by existing precedent. The Supreme Court of the United States, in order to strike down the mandate and penalty, need overrule no case, need modify no doctrine. It just has to refuse to extend congressional power. And what we argue is that there are, in fact, established affirmative and negative outer limits to the Commerce Clause. The affirmative outer limits have to do with what the Supreme Court has permitted under the Commerce Clause and Necessary and Proper Clause. And all the Supreme Court has ever permitted is the regulation of the channels and instrumentalities of interstate commerce, the regulation of things and persons in interstate commerce, and employing the Necessary and Proper Clause, they have permitted the regulation of activities which materially affect interstate commerce. Now, probably the most radical employment of that third category is in what is famous to lawyers, but probably not to non-lawyers, the so-called wheat case, where in 1942, in a case called Wickard versus Filburn, Roscoe Filburn was growing wheat on his own farm and not selling it. And nonetheless, he was found to be subject to federal regulation under the Commerce Clause. Now, in fact, the founders probably didn't view agriculture as being a commerce, but at least it made economic sense and kept the decision tethered to the text of the Commerce Clause by saying, well, if this wheat is a commodity, a fungible commodity, whose existence will affect demand and price, then we're going to permit that regulation under the Commerce Clause as an activity affecting commerce. Now, the case is really not as radical once you look at it as everyone claimed it was for most of its existence, because the parties stipulated that Mr. Filburn was feeding his wheat to his cows and chickens and then selling those products. And they also stipulated that homegrown wheat accounted for 20% of annual variation in price. So it was not viewed from a practical standpoint, it was not that radical a case. Now, it's been recently reaffirmed in a case called Raish, where Angel Raish was growing marijuana in her kitchen for medicinal purposes. And the court said that under the Commerce Power, the federal government could forbid the homegrown marijuana market, or not market, because it was not a market, it was just an activity. But this really doesn't take us any further than Wickard, because Randy Barnett, when he argued Raish, conceded that the statute was not facially unconstitutional. Well, what Wickard stands for is the proposition that we're not going to let you atomize your own conduct and say that it's too small to be regulated, because then you couldn't regulate a commodity at all. As Justice O'Connor said in her dissent in Raish, the challenge is to how to regulate less than everything by letting Congress frame the scope of its own power, and regulate more than nothing, which is what you would have if you could atomize it. So, and it's also true that if you're making an enumerated powers challenge, that the only way you look at that is as a facial challenge, not an as-applied challenge. So once Professor Barnett had conceded facial constitutionality, that case was lost. It was going to come out the way it came out. So we would say even the broadest cases, cases that used to be, Wickard used to be said to stand for the proposition that Congress can now regulate anything. Professor Curry said that in his history of the first 100 years of the Supreme Court. They're not that radical, and this is radically beyond them. We also argue that there are established negative outer limits to the scope of the Commerce Clause. In Lopez, which was the federal Guns School Act case where there was a federal law that did not permit a gun within 500 feet of a school, and in Morrison, which came out of Virginia, where the Violence Against Women Act had created a federal tort for an assault on women, and a football player at Virginia Tech was accused of having assaulted the plaintiff. The Supreme Court said, this court has always refused to accept a reading of the Commerce Clause and of federal power that has no principal limit and therefore would be tantamount to the recognition of a federal police power. So our position is we're not the ones arguing for a change in the law. This enactment is beyond the affirmative and negative outer limits of the Commerce Clause. So our challenge is modest. On the other hand, the arguments that favor Congress's power to require a citizen to purchase a good or service from another citizen lack principal limits and are therefore doctrinally extravagant. The real issue comes down to this. I got to do, by the way, as part of speaking about this issue, as I have to other groups, I got to do something that every law student should get to do. I got to debate my con law professor on the subject, Walter Dellinger. And basically what Morrison and the negative limits of the Commerce Clause cases stand for is the proposition that the necessary and proper clause can't be used contrary to prohibitions in the Constitution. And those prohibitions are not limited to express prohibitions. They include the provisions of the Constitution that give rise to structural federalism. So an act could be necessary within the necessary and proper clause merely because it's convenient. Because as early as John Marshall, it was held that necessary doesn't mean strictly necessary, just well adapted and convenient. So something can be necessary, but not proper, if in fact, by recognizing the power, you are violating structural federalism. And so when I debated Professor Dellinger in front of a group, I said it all comes down to this, that I think that there is a proper wing, a proper prong to the necessary and proper clause, and Professor Dellinger doesn't. And when he stood up, he said, that's right. So the case may be as narrow as that. The problem for the federal government has precisely been trying to find a limiting principle. A law professor has said something, written something that I agree with. He said that if the Solicitor General of the United States is standing at the podium and the white light is on and he hasn't come up with a limiting principle, he doesn't have 5 votes. I don't forecast what courts are going to do, and so I don't know that's true, but it certainly is a plausible view of the predicament in which the federal government finds itself, because they're arguing that this power should be recognized, but there's no limitation to it except repeatedly, at least in our phase of the litigation, they kept repeating the mantra that health care is different. And health care is supposedly different because everybody is going to need health care and nobody knows when. But the fact of the matter is that that's true of all goods and services, or at least essential ones. I mean, it's not true that you don't know when you're going to need food, but it is true that you could distort the market in any fundamental good or service, and then say it has now become necessary it has now become a unique problem because of the distortion, and therefore we've added to the powers of Congress. I don't think that's what the necessary and proper clause was supposed to mean, that you can fundamentally change the scope of power by enacting a legislation that distorts the market and then say you have to, it's necessary and proper for you to pass something else in order to deal with the problem. And of course what I'm alluding to is the federal requirement that all hospitals that accept Medicare, Medicaid money have to treat anybody in the emergency room. The EMTALA Act, only the Shriners and the VA hospitals would not be subject to that. But in any event, I don't think that the answer is health care is different because, quite frankly, if mandates are permissible, if you can mandate in order to regulate commerce, then what is to stop Congress from saying that you must use your 401k to purchase a new government retirement annuity? A committee of the House of Representatives actually had a hearing on that before the 2010 elections. Mandates are very broad things that if they're valid, then it's somewhat alarming. The issue then in the end will come down to whether or not the court really meant what it said in Morrison, which is, and I'll give you the quote exactly, I paraphrased it before, and that is this court, quote, always has rejected readings of the Commerce Clause and the scope of federal power that would permit Congress to exercise a police power. I will take a minute because I have a few left before the scheduled question and answer session to talk about the tax argument, the argument that perhaps the bill could be sustained, the law could be sustained based upon the taxing power. And this is an interesting, in my estimation, artifact of the blogosphere. Because although Congress, in a House version of the bill, did, rested authority on taxing power and try to use taxing and spending powers, that basically everyone denied that the mandate and penalty were taxes. The president famously did so. But law professors began to appear in the blogosphere and say, well, this is easy. We don't have to win on the Commerce Clause. We can justify this as a tax. And I think that led the Department of Justice to adopt the argument. It turns out not to bear scrutiny because the penalty is not a tax. What is and isn't a tax is justiciable. Courts decide whether something is a penalty or a tax. They're accustomed to doing so. And the distinction is this: a tax is an exaction for the funding of the government, and a penalty is an exaction for having performed an illegal act. And even though the penalty is productive of revenue, it doesn't make it a tax. And so you have to observe as well, although DOJ referred to the penalty in our litigation, and I believe in Florida as well, as a tax penalty, It's not a tax penalty. It's not a penalty that you have to pay because you didn't pay your taxes. It's a penalty you have to pay because you violated a command. And that makes it just a naked penalty. Well, a naked penalty requires an enumerated power to support it. And if that power is not the taxing power, then what other plausible enumerated power is there to support it? Well, the only plausible, colorable enumerated power to support it would be the Commerce Clause. So the tax argument collapses back into the Commerce Clause, and it gets you nothing. But it was thought to be the silver bullet by certain commentators and bloggers as the litigation went forward. There was a strong reaction from the professoriate when these suits were filed, that they were insubstantial, that they were frivolous, because ever since the Roosevelt Revolution, the federal government has been sustained in its exercise of commerce power. But setting these cases down for 3 days is not an indicia that it is frivolous. It is not an indicia that it is even weak. It's a strong recognition that what we have here is something entirely new. This is not 1938, and PPACA is not the agricultural act being reviewed in Wickard. This is something entirely new. It is a novel claim of power. It is a dangerous claim of power. And it will mark a watershed in the relations between state and between federal government and citizen if the power is found to exist. On the other hand, if it is found to be unconstitutional, nothing changes. We still have the same doctrines with respect to the Commerce Clause. It's very broad. Congress can regulate activities substantially affecting commerce. What Congress can't do is to say, we are ordering you, citizen, into commerce so we can regulate you in the name of commerce. So again, I think the three bullet points are that the claim power is novel. I think that the argument against its constitutionality is very modest. And I think the claim for its constitutionality is extravagant. And I'll be happy to take questions.
I'm an econ major and not perspective pre-law or anything like that, so I might get out of my depth a little bit here. But I've just been thinking, maybe what if, rather than having an individual mandate, the federal government made 2 amendments to the tax code. The first is it had a lump sum tax on all citizens, and then second, it had a refundable tax credit that was equal in value if you purchased insurance. Would that be constitutional?
Again, as we pled in our complaint, and I'd have to see the details to make sure it's not just a subterfuge, because there is a case from the 20s called the child labor tax case, which has never been overruled. And basically, it says that the court will not defer limitlessly to Congress's claims that it's exercising the taxing power. And if what it's really doing is seeking to regulate in an area beyond its enumerated powers, that calling it a tax won't save it. But in broad principle, the Congress had every power under the taxing and spending clauses to have national health care. We're not saying that we're uniquely among modern states a country that can't have that. You just can't command a citizen to purchase insurance from another citizen. Yes, sir.
I have kind of maybe two related questions. First, I didn't quite understand what point you were making when you talked about there's a mandate for institutions that accept Medicaid, Medicare to treat anybody who comes in the emergency room, because it seems to me that does sort of support that you would be able to say that everybody should then have to buy insurance. And the other is, isn't there something different about marijuana or wheat versus somebody not buying insurance and making my premium go up? You alluded to some temporal factor. Well, you don't know when it's going to happen, but it's going to happen. It does happen. How is that not something involved with commerce that would be supported?
To answer the second question first, wheat growing even on your own land and marijuana growing even in your own kitchen is an activity that has an effect on the common stock of a commodity. And so you have not completely untethered congressional power from the text of the Commerce Clause to uphold that. If I am deployed abroad in Afghanistan, if I'm sitting on my couch uninsured in Hanover, New Hampshire, I'm not doing anything. And so if you want to say I can regulate that as commerce, then I would say with all respect that we have approached the level of postmodernist wordplay, because it's not commerce. I'll tell you a story. I'll make it short. If you're representing Virginia on a question involving original intent of the founders, it's a lot more fun than if I were doing it in Colorado, because Virginia still has the stuff. So when I was thinking about making the textual argument for what commerce means, it occurred to me that our classically educated founders would know that the English word commerce comes from the Latin commercium. And so I went over to the state library, the Library of Virginia, and I asked for all the Latin dictionaries and all the English dictionaries before 1789. And it was clear that, yes, they knew that commerce comes from the Latin word. And one of the Latin dictionaries that I cited, I looked on the flyleaf, and it was signed P. Henry. So I was using Patrick Henry's own dictionary. The fact of the matter is, commerce doesn't mean sitting on your couch not doing anything. It just doesn't. And regulation of commerce necessarily means you're regulating some pre-existing activity, not dragooning somebody into commerce in order to regulate them, if words are to have any integrity. Now, with respect to the issue of ordering emergency rooms to treat people, I was simply observing that the government's argument that health care is different is really not intrinsically true. It's just a result of market distortion that EMTALA created when people were ordered to treat people. Yes, sir.
So I have a question about the government case. You said that the Solicitor General has to provide some sort of standard as to how far the Commerce Clause go, what the limits are. What do you think that standard is going to be in March, and if he's going to propose one at all? And what would your response be?
I don't think that they're intrinsically capable of coming up with a limiting principle, because I don't think there is one. If you say, in order to make my regulation of commerce work, I get to order people who are in repose to do things, I know of no principal limit to that claim power. And, you know, not to be flippant, but more power to them if they can think of one. Yes, sir.
I was curious in terms of laying out the context within which the bills were passed in the first place. Who would you be speaking to on the court to make that argument? And it seems like the ones that would more likely go into the unconstitutional side could care less what the context was and only what the text says. So that the sort of the narrative that goes around that really wouldn't play to the people that are more likely to vote on the unconstitutional side.
Justice Breyer, in his book Active Liberty, says that all the justices agree on 4 of the traditional sources for constitutional construction: text, historical context, tradition, and precedent. And what I have tried to show is that all of those traditional sources of constitutional construction are against the validity of PPACA. Now, it is true that Justice Breyer says that there are justices such as himself that will use 2 other criteria. One is there an overarching purpose to the enactment? And the other is policy results. Well, those 2 would be more likely to support a finding of validity than the 4 more traditional ones. But I don't think that anybody has ever said that you can disregard the 4 in order to uphold something under the 2. Because that's just saying our policy preference is for this law. So I mean I think there is obviously a very meaty question that's recognized as a meaty question, or the court wouldn't be setting it down for 3 days of argument. Yes, sir.
Policy implications being less important to the votes that you would be courting. To what extent does the fact that current state regulation of health insurance exists helpful to your structural federalism claim?
I'm not sure I understood it because I don't think I heard it.
So to what extent does the status quo existence of state regulation of health insurance and health insurance markets support your structured federalism claim, given that those 4 votes don't really depend on policy?
Well, I'm not going to accept whose vote depends on policy and whose vote doesn't. I don't characterize individual justices, but the fact of state regulation is more complicated than it looks, because up until the 40s, the Supreme Court had said that the business of insurance is not commerce. And so when the Supreme Court in 1948 said, oh, yes, it is, then Congress immediately passed the McCarran-Ferguson Act and said, unless we expressly say that we're regulating insurance, we want it to stay with the states where it traditionally has been. So since 1948, the fact that the states actually do regulate it for the most part, or have regulated for the most part, actually doesn't do much for the inquiry of whether or not Congress can if it wants to. Yes, sir.
Thank you. While listening to your presentation, one of the thoughts that came to mind was a comparison between the requirement to purchase health insurance and the requirement to purchase car insurance. Now, obviously, there are inherent differences between the two, but using the comparison with the act of driving, merely not simply the purchase of a vehicle, but the mere act of operating the vehicle, you're required to have insurance. I just was wondering if you could kind of highlight the fundamental differences between these two acts.
Excuse me. The difference is this, that requiring people to do things affirmatively is an exercise of the police power. That's why states can require children to be vaccinated before they go to school. That's why they can require insurance before you can drive on the highway, because states have the police power. The federal government is not supposed to have it. And in an effort to try to find some historical example of when the federal government has required somebody to act, nobody can find anything under the Commerce Clause. The closest thing you can find is under the war powers. In the Militia Act of 1792, people had to show up at militia muster with a gun. I didn't say they had to buy it, they could make it or borrow it. But the federal government traditionally can require you to do things closely connected with a core function, an enumerated function. So it can draft you into the Army. But those are requirements of citizenship. The notion that the Commerce Clause, that the words regulate commerce between foreign nations, the several states, and the Indian tribes means they can order you to affirmatively do things is an exercise of the police power, and precisely what we say the federal government can't do under Morrison. Yes, sir.
I think you may have answered this question.
Sir, speak into the mic.
Oh, here it is. You may have answered this question in your last answer. But what is the Solicitor General of the United States' answer to the distinction which is founded on this, that namely what this statute, the mandate, seeks is to govern behavior simply by virtue of the existence of an individual. So taking that to its extreme, if it's found to be constitutional, what would prevent the federal government from affecting behavior in many different ways that have an ultimate intended impact on health? For example, everybody in this room has to take a walk for a mile every day. Everybody has to take Advil, all of which has as its ultimate consequence affecting the health of individuals. And that's distinguishable, it seems to me, from the person who is already growing marijuana or the person who is already engaged in wheat production. It's merely by virtue of existence, and the government is seeking to control behavior. What is the Solicitor General's answer to that?
I don't think he has a good one. I mean, I agree with you. This is what has been characterized as the broccoli argument. If the government can make you buy health insurance, it can make you buy broccoli. And then in the academy, the professors have then begun to discuss, well, you can't make them eat it because that would violate an amendment or due process. The fact of the matter, though, is that the former Solicitor General under Reagan, who's at Harvard, has seriously and publicly said, yes, you can make people buy broccoli. I do think that there's a fundamental divide between a citizen at repose, who I think has a liberty interest in that repose under the founder's view of the world, being ordered about for the convenience of the government. I think it's a very important distinction that you can't do that.
So I was wondering that if this were to be declared unconstitutional, I was wondering what type of healthcare policy you would hope or expect to see replace it under whoever is the next president.
I don't have a policy interest in this. My involvement was I represent the Commonwealth of Virginia, and the Attorney General's office has a statutory duty to defend statutes of the Commonwealth that can be defended. When the General Assembly passed the Virginia Healthcare Freedom Act that said no Virginian can be required to purchase a policy of insurance, it was our duty to defend that if it were defensible, and it is. People have tried to dismiss that as some species of nullification, but it's not at all. What it is an attempt to exercise police power within this subject area. And if we're correct that the federal claim to power is beyond the outer limits of the enumerated powers, then we may validly do so. If we're wrong, and Congress did have the authority to pass the mandated penalty, then our act is in conflict with a valid federal law, and it falls under the Supremacy Clause. But the Supreme Court has made it clear that the Supremacy Clause and the 10th Amendment are answers to the question. They're not the independent rule of decision. The antecedent question is, does Congress have the power? If Congress has the power, you shoot out the Supremacy Clause pipe. If Congress doesn't have the power, you shoot out the 10th Amendment pipe. And so the question is, does Congress have the power to do something it has never done before and never even claimed to have the power to do before? And that's the interesting question that the U.S. Supreme Court gets to decide. Yes.
So, should the individual mandate be found unconstitutional, what do you think will happen to the act as a whole? Is it severable, as you mentioned in the beginning?
I would be very surprised if it is found to be completely severable. I don't think that the result reached in the 11th Circuit is correct. If it's unconstitutional, if the court wants to give vitality to the legislative bargain concept, I think the whole act falls. But if the court wants to say, well, what could Congress have validly passed and still have wanted to remain in effect if the mandate and penalty fell, there's some things in the bill that are completely standalone. And so I suspect that the court, if it finds it unconstitutional, will cut more broadly, more than the 11th Circuit did, but I can't forecast whether they will cut at the bone, as it's sometimes said, or whether they'll strike the whole thing.
Sorry, so I understand what you're saying about there being some pieces of the bill that could be severable and others that are not, and I respect that you're coming to this whole debate from like a constitutionality standpoint, but do you see the violation of constitutional rights as being a greater threat to Americans than the current state of healthcare in this country, and the fact that if the law the mandate is ruled unconstitutional and several other provisions of the law go down with it, and healthcare costs continue to rise at the rate that they do, and millions of Americans go uninsured and don't receive the quality care that they need, that isn't as big of a threat to Americans?
There is a statement by the Supreme Court, I think, in a case called New York versus United States, that's repeated in the bond case that I cited earlier, that every generation has its policy, feeling of policy urgency, and that if we said we're going to override the Constitution to serve that policy imperative, that the cure is far worse than the disease could ever be.
Along the side of your comment on healthcare is different, though I agree with that, can you elaborate more on Congress saying that this is a systematic change, though you commented on it's not because we should be doing the same with Medicare and other healthcare services, though I believe that CMS is already doing that with the types of payments that Medicare is receiving and distributing. So I was wondering if you can elaborate more on the systematic changes that the healthcare law brings.
I was discussing the systematic changes in financing only from the standpoint of trying to identify whether or not all the financing changes are implicated in the question of what can remain and still function as Congress intended. Because if in fact you strike down the insurance changes, I don't think the Medicare and Medicaid changes are working the way Congress intended them to work if the insurance piece had still been in there. So I think that the argument can be strongly made that all of the financing is unseverable, but again, it is complete reading of tea leaves as to what a court will do in severance if it strikes less than everything. I'm not even sure the court is equipped to deal with it on this record. I suspect what the court would do if it strikes it down as unconstitutional is remand to the 11th Circuit, which probably would remand to the district court to consider in detail through expert testimony what works with what.
Given the unusually extended amount of time allotted by the court to arguments in the spring, do you think that this is an indication that the court doesn't see this as such a clear-cut constitutional case where the various clauses don't allow for the healthcare mandate?
I think that cases that the court doesn't think present substantial constitutional questions, they don't take. And if they take them, they dispose of them in the ordinary time that their rules provide, which is 30 minutes aside. I think that the fact that this has been set down for 3 days of argument is some sort of tacit recognition that this is a watershed case.